All right, welcome back. I've got an exciting update up in Idaho today, and so I realized that I had quite a backlog up there, but today's update renders most of that backlog moot. So I'm just gonna summarize it looking at the docket. But first, so First, remember, Professor Scofield has her GoFundMe. I'll have it linked in the description. We've had a lot of entertainment from this case, so pay it forward, help her keep the case going. Of course, the case just, the update is basically the case is cut in half. Um, so, but before I get to Idaho, so story time. I've mentioned many times my brother lives next door with his 3 kids, but my sister lives about a mile and a half away with my youngest nephew, who is 4 years old. So, Sunday dinner, I'm putting together my burger, and he comes up to me and he goes, "Uncle Joe, have you heard about the bird?" Because the bird is the word. And it's had me cracked up all week, so I just thought I'd share it with you guys. So, with that, hmm, we'll see if my computer is going to annoy me. Flickering. But we'll jump over to the docket and scroll down, find where we were last time. So, you'll remember I looked at both discovery plans back in June. Spoiler alert, Rebecca Scofield's discovery plan will control from here out. And what we have okay. So last time we were here, we had Ashley Guillard's response to the motion to dismiss the counterclaims. So remember, Ashley Guillard brought frivolous counterclaims against Professor Scofield. Professor Scofield moved to dismiss a 12b6 motion. Last time we were here, we had Ashley Guillard's response opposing the 12b6. And I can't remember, we might have covered her response to the motion to quash the summonses, because once again, she inappropriately tried to claim Professor Scofield's attorneys as counterclaim defendants as well, even though it was inappropriate. So instead of defending those counterclaims, the attorneys moved to quash the summons completely. And so, let's see, 2 days. Wait. Either way, okay, I see what I'm getting wrong here. We had the stricken response, and then we had the official response filed on the 30th to the motion to quash, and the response for the motion to dismiss on the 29th of June. Okay. And then we had a scheduling order basically setting a telephonic conference. So it was a court hearing, but over the telephone. And this was, unfortunately, or no, sorry, I'm getting ahead of myself. This was a scheduling plan. The one I'm getting ahead of myself on is on July 21st, there was an actual hearing to argue the motions to dismiss. And unfortunately, that was the day I was getting ready for my vacation. So I wasn't I wasn't able to dial in and listen. I couldn't have recorded it anyway. So for that, Emily Baker did dial in, and she's got a good video shortly thereafter detailing that. So go watch that. And so that's this docket number 39 sets that up for July 21st. We had a motion to continue the deadline for filing responsive pleadings. So basically what that was is the attorneys said, hey, judge, we've got a motion to quash, but there's also a looming deadline for us to make a responsive pleading, for us to either answer or do a motion to dismiss. But we've got the motion to quash, which if it's granted, we won't have to go through that time. So why don't you just extend the deadline for a responsive pleading until after the motion to quash has been ruled on, which the judge granted in number 43 here. And then we got a reply by Professor Scofield in support of the motion to quash. So it was a reply to Ashley Guillard's response. And then we got a fun one on July 13th. We got a motion for sanctions by Professor Scofield asking the judge to sanction Ashley Guillard. Now, why is this one exciting? Well, two reasons. Number one is, you may remember in her answer, one of the counterclaims Ashley Guillard brought was Rule 11. I deserve Rule 11 sanctions as a cause of action. And you may remember, I lost my mind because Rule 11 of the Federal Rules of Civil Procedure is not a cause of action. There is no cause of action rooted in the Federal Rules of Civil Procedure, or state rules for that matter. But all causes of action have to be pled in accordance with the Federal Rules of Civil Procedure, but the rules don't provide a cause of action. Rule 11, you bring a motion for sanctions, or the court can impose sanctions on its own, sua sponte, but that's within the litigation. It's not a cause of action. So this shows us, you know, this is how you do it. And what were they bringing sanctions for? Well, asking for sanctions for. They asked for sanctions because Ashley Guillard's been arguing things that are not rooted in law or in fact. Now, I don't think that this is going to be granted, but they brought it. And the judge, as we'll see, the judge agrees. The judge agrees with their argument, but I don't think sanctions will be granted. But, you'll notice this was brought July 13th. I'm recording this on August 10th. It's been well over 21 days since this was brought. It's past the deadline for a responsive pleading. I do not see a responsive pleading for the motion for sanctions. Of course, even without a responsive pleading, the court can just deny, but it's easier to deny if if the opposing party has actually opposed. So then we had, on the next day, on July 14th, a reply from Professor Scofield on the motion to dismiss. And then we had a minute entry for the proceedings. Basically, it said, yeah, we had this court hearing by telephone. The parties were present and argued. And like I said, go watch Emily Baker's video on that. Emily's excellent. She's frankly much better than I am, but I appreciate you being here just the same. But one of the takeaways is the judge asked Guillard, what are your facts? And basically she said, I believe what I said, and that should be enough. But what are the facts? And she said, well, the Professor Scofield is a professor at the University of Idaho, and the students were students at the University of Idaho. And if you don't throw this out, I should be able to find the rest in discovery. You know what we call that? A fishing expedition. Or I'm not going to spoil it yet, but I like the way the judge put it. I really like the way the judge put it. So finally, we had a motion to quash or modify the subpoena to Meta platforms by Professor Scofield. So basically, Ashley Guillard did it was a shotgun subpoena to Facebook. It wasn't targeted. It was, it wasn't even buckshot. It was birdshot. It was scattered. It was as big as she could do. And Professor Scofield saying, hey, wait a minute. You can subpoena Facebook. You can get some of the records, but you can only get the relevant records. And so I am going to go over this second, but I'm going to do the judge's order first. And I think the judge's order actually is going to probably give this a pretty good shot of being granted. So finally, on August 8th, we got a memorandum decision and order, and we'll take a look at what it says on the docket first, and then we'll go to the document. So plaintiff's motion to dismiss defendant's counterclaims is granted in part and denied in part as follows. Defendant's counterclaims against plaintiff are dismissed with prejudice. They're gone and they're not coming back. That is great news for Professor Scofield. They were frivolous from the outset, just absolute ridiculousness, and the judge agrees. So as far as the motion to dismiss, that part was granted in full with prejudice. But the in part denied, well, we'll get to that. So in this respect, plaintiff's motion to dismiss defendant's counterclaims is granted. An attorney's fees award against defendant is not warranted at this time. So that's the part that's denied. No attorney's fees yet. They might be granted at the end of the case, but not yet. So next, plaintiff's motion to quash summonses for the attorneys is granted. Because plaintiff's counsel is not a party to the action, any consent deadline directed at plaintiff's counsel is inapplicable and hereby vacated. Consistent with paragraph 4 of the court's scheduling order, plaintiff's proposed discovery plan controls unless otherwise ordered. So I hinted at that earlier. Of the competing discovery plans, Professor Scofield's controls. And it's signed by U.S. Magistrate Judge Raymond Edward Patrico and mailed to the defendants unless it was ECF. So that's the docket. Now let's jump to the document. And I'm a big fan of this judge. Pending before the court are 1. Plaintiff's motion to dismiss defendant's counterclaims, and 2. Plaintiff's motion to quash summonses for the attorneys. Having carefully considered the record and participated in oral argument, the court grants both motions. Defendant's counterclaims are dismissed against plaintiff and plaintiff's counsel, and the summonses issued for plaintiff's counsel are quashed. And footnote 1, I missed the indication. Oh, the indication for the footnote was up in the caption for counter defendants because it's still captioned Professor Scofield and the attorneys. The court acknowledges that the attorneys contend that they are not actually proper parties to this lawsuit. Their reference in the caption simply reflects defendants' claim that these parties are properly before the court. This memorandum decision and order resolves that issue based upon the current arguments before the court. So, 1. Factual and procedural background. This case arises out of the tragic murder of 4 University of Idaho students in November 2022. Plaintiff Rebecca Scofield is a professor at the University of Idaho. She alleges that she never met the students and was not involved with their murders in any way. Notwithstanding, plaintiff alleges defendant Ashley Guillard posted over 100 sensational TikTok videos falsely claiming that she had an inappropriate romantic affair with one of the victims and then ordered the murders to prevent the affair from coming to light. In turn, plaintiff initiated this action on December 21st, 2022, asserting 2 defamation claims against defendant. One is premised upon false statements regarding plaintiff's involvement with the murder themselves. The other premised upon false statements regarding plaintiff's romantic relationship with one of the murdered students. So I always find it kind of funny that you'll notice when there are counterclaims, it's frequently they bring the kitchen sink approach to the counterclaims. So Professor Scofield brought 2 counts, both defamation, one for alleging murders and the other for alleging inappropriate affairs. Ashley Guillard brought 11, just trying to find something that would stick, I think. Pro se counter plaintiffs, I think, do this more often, but even represented defendants do this on counterclaims as well. And it just, if it's frivolous on a original complaint, it's also frivolous on a counter complaint. So just don't do it. But either way, defendant, representing herself, did not immediately respond to plaintiff's complaint by the January 17th, 2023 deadline. See Federal Rule of Civil Procedure 12A1A1. A defendant must serve an answer within 21 days after being served with the summons and complaint. As a result, pursuant to Rule 55A, plaintiff moved for an entry of default on January 19, 2023. A clerk's entry of default was then entered and mailed to defendant on January 27, 2023. On February 16, 2023, defendant moved to set aside the entry of default. Plaintiff responded the next day, opposing defendant's efforts to set aside the entry of default and filing a motion for default judgment pursuant to Rule 55B2. On April 24, 2023, the parties consented to the undersigned magistrate's jurisdiction. Thereafter, on April 26, 2023, the court granted defendant's motion to set aside entry of default, denied plaintiff's motion for default judgment as moot, and ordered defendant to respond to plaintiff's complaint within 21 days. On May 16, 2023, defendant filed her answer, affirmative defenses, and counterclaims to complaint. Within her answer and counterclaims, defendant denies that she defamed plaintiff because the accusations made against plaintiff in defendant's TikTok videos are substantially true. Defendant maintains that she used her spiritual brain, intuition, spiritual practice, and investigative skills to uncover the truth regarding the murder of the 4 University of Idaho students, and published her findings on her TikTok social media platform. Relevant here, defendant also affirmatively asserts 11 counterclaims against both plaintiff and her legal counsel. Defendant's counterclaims rely on 2 premises. 1, plaintiff initiated, planned, and executed the murders of the 4 University of Idaho students to cover up an affair she had with one of the victims. And 2, plaintiff sought to evade suspicion for these murders by conspiring with her counsel to file a frivolous complaint with falsified factual allegations that A, supported the defamation claims against defendant, and B, deprived defendant of her constitutional rights. Defendant further asserts that the conspiracy between plaintiff and her counsel extended beyond the mere filing of plaintiff's complaint. It also included plaintiff's counsel's defamatory statements to the media about plaintiff's underlying lawsuit against defendant. Defendant alleges that, owing to plaintiff's and her counsel's conduct in these interrelated respects, she has been presented in a false light, harassed, including death threats, deprived of her good reputation, and prevented from pursuing her livelihood. She therefore asserts the following counterclaims against plaintiff and her counsel. First counterclaim, defamation, 28 U.S. Code, Section 4101. Press releases and false statements alleging that Ashley Guillard made false statements regarding Rebecca Scofield's role in the murder of the 4 University of Idaho students, knowing they are false. Second counterclaim, defamation, 28 U.S. Code, Section 4101. Defamatory lawsuit alleging that Ashley Guillard made false statements regarding Rebecca Scofield's role in the murder of the 4 University of Idaho students, knowing they are false. Third counterclaim, 42 U.S. Code, Section 1985-2, obstructing justice, conspiracy to interfere with the right to due process and the freedom of speech. Fourth counterclaim, 42 U.S. Code, Section 1986, action for neglect to prevent 42 U.S. Code, Section 1985-2, conspiracy to interfere with the rights to due process and the freedom of speech. Fifth counterclaim, 42 U.S.C. Section 1983, civil action for the deprivation of rights, deprivation of the right to due process that's guaranteed by the 14th Amendment of the U.S. Constitution. Sixth counterclaim, malicious prosecution, frivolous claim. Seventh counterclaim, malicious prosecution, frivolous claim. Eighth counterclaim, 42 U.S.C. Section 1985, Sub 2, obstructing justice, conspiracy to interfere with the right to due process, improper venue. And you'll notice, once again, both of the 1985 claims are for the second section of 1985. But in her opposition to the motion to dismiss, she'd alternately argue Section 2 and Section 3. I don't think she ever argued Section 1, but she might have. But she tried to support her claim by saying, well, but look at Section 3. And it's like, but you didn't bring a claim under Section 3. You only brought a claim under Section 2. Section 3 doesn't help you. Ninth counterclaim, 42 U.S. Code, Section 1986, action for neglect to prevent 42 U.S. Code, Section 1985-2, conspiracy to interfere with the right to due process that's guaranteed by the 14th Amendment to the U.S. Constitution. 10th counterclaim, intentional infliction of emotional distress, frivolous claim. And 11th counterclaim, intentional infliction of emotional distress, multinational press release and news coverage defaming Ashley Guillard. Plaintiff moves to dismiss each of these claims against her. Footnote 2, the motion to dismiss does not speak to defendant's counterclaims against plaintiff's counsel because plaintiff's counsel contend they are not properly part of this action. So plaintiff moves to dismiss each of these claims against her, arguing that they are not only factually implausible, but legally deficient. Where did we hear that earlier in this video? It was when I mentioned the motion for sanctions. That Professor Scofield brought a motion for sanctions because not just the counterclaims, but her Ashley Guillard's arguments in general were factually implausible, deficient on facts, and legally deficient. It's what's legally deficient? Well, remember when I just go way back to when I first covered the counterclaims, way back in Ashley Guillard's answer. And I've mentioned it several times since. Let's mark where I am. And we first and second counterclaims. Defamation, 28 U.S. Code, Section 4101. I've mentioned this many times before, like I said. 4101 is a definition section for what counts as a defamation judgment for the purposes of enforcing a foreign defamation judgment in federal court. That's all it is. But she claimed that as a cause of action. That's legally deficient. So even if she had been defamed, even if she had been defamed, 4101 is not the legally proper cause of action. It isn't a cause of action. It's a definition. It's ridiculous. So, further, plaintiff moves to quash the summonses for her counsel, arguing that their issuance is procedurally improper. Each of these motions is ripe for the court's consideration and resolved below. So, one of the requirements for a court to hear a case, to hear a motion, is that the issue has to be ripe. It cannot be moot. So the court says right here, hey, these are not moot issues. These are ripe for the court's consideration. Another requirement, which I think is going to come up in one of the recent filings in, I think it's in Floyd's case, Floyd Wallace. It might be in DeCastro versus LVMPD, but in one of them, no. I think it was Floyd's, but if I remember right, they basically in one of their motions said, "Well, court, give us a hint what you're looking for," which would be kind of either what frauditors always spout: you can't practice law from the bench, so getting legal advice from the court, or it would be an advisory opinion, which courts do not grant. That's taught in the same section as mootness or ripeness, the other side of mootness. So, discussion. Plaintiff's motion to dismiss. Motion to dismiss standard. How much of this have you heard me discuss before? Rule 8A2 requires only a short and plain statement of the claim showing that the pleader is entitled to relief, in order to give the defendant fair notice of what the claim is and the grounds upon which it rests, citing Twombly, our old friend. While a complaint attacked by a Rule 12b6 motion to dismiss does not need detailed factual allegations, it must set forth more than labels and conclusions, and a formulaic recitation of the elements of a cause of action will not do. That's also Twombly. To survive a motion to dismiss, a complaint must contain sufficient facts accepted as true that state a claim to relief that is plausible on its face. Plausible. Tarot readings are not plausible. As the court will say, it's implausible. A claim is facially plausible when a plaintiff pleads sufficient facts to allow the court to reasonably infer that the defendant is liable for the misconduct alleged. The plausibility standard is not akin to a probability requirement, but it requires more than a sheer possibility that the defendant acted unlawfully. It simply calls for enough fact to raise a reasonable expectation that discovery will reveal evidence of unlawful conduct. Where a complaint pleads facts that are merely consistent with the defendant's liability, it stops short of the line between possibility and plausibility of entitlement to relief. Two working principles underlie the pleading standard, and this is Iqbal. First, the tenet that the court must accept as true all of the allegations in a complaint is inapplicable to legal conclusions. Can we tattoo this to Delete Law's forehead? Legal conclusions, especially misstatements of legal conclusions, but legal conclusions are not pled facts. They are not given weight. Basically, they do not need to be accepted as true. Let's put it that way. Legal conclusions do not need to be concluded as true. So, Delete Laws, when he says, there was no probable cause to arrest me, that doesn't have to be taken as true because that's a legal conclusion. I know that's a different case than what we're covering right now, but that's just an example of what a legal conclusion is. And secondly, Rule 8 marks a notable and generous departure from the hyper-technical code pleading regime of a prior era, but it does not unlock the doors of discovery for a plaintiff armed with nothing more than conclusions. We're going to see the court basically addresses exactly that later on. Second, only a complaint stating a plausible claim for relief survives a motion to dismiss. Whether a complaint states a plausible claim for relief is a context-specific task that requires the reviewing court to draw on its judicial experience and common sense. Courts generally construe pro se parties' filings liberally. That's Barrett versus Belloc, Ninth Circuit, 2008. Even so, a court may dismiss as frivolous claims that are clearly baseless, a category encompassing allegations that are fanciful, fantastic, and delusional. That's Denton versus Hernandez, Supreme Court, 1992, which says, as those words suggest, a finding of factual frivolousness is appropriate when the facts alleged rise to the level of the irrational or the wholly incredible. Wow. Does that fit here? I think that fits here. And see also Knightsky versus Williams, also Supreme Court, 1989. The term frivolous, when applied to a complaint, embraces not only the inarguable legal conclusion, but also the fanciful factual allegation. In this context, claims that are clearly baseless are likewise not facially plausible under Twombly and Iqbal. When a court grants a Rule 12b6 motion to dismiss, a plaintiff is ordinarily entitled to amend the complaint before the action is dismissed. That's Lopez versus Smith, Ninth Circuit, 2000. See also Federal Rule of Civil Procedure 15a. The court should freely give leave to amend when justice so requires. Rule 15's policy favoring amendment should be given with extreme liberality. That's citing DCD Programs Limited versus Layton, Ninth Circuit, 1987. This is especially true when a plaintiff is pro se. That's Lopez again. Leave to amend should be withheld, however, if the amendment, 1, prejudices the opposing party, which that's not a very good standard because, frankly, what level of prejudice? Because me having to defend myself in court prejudices me. It's a question, is it unfair prejudice? Is it unlawful prejudice? Prejudice is practically meaningless here unless it has some level or some context to the disallowed prejudice. 2 is sought in bad faith. 3 produces an undue delay in litigation, or, as is the case here, 4, it is futile. That's Amerisource Bergen Corp versus Dialysist, Ninth Circuit, 2006. Defendant's counterclaims against plaintiff are factually implausible. Once again, remember that motion for sanctions. It's factually implausible and it's legally improper. So, defendant responds to plaintiff's defamation claims against her by going on the offensive, alleging that those claims, as well as statements made by plaintiff's counsel to the media about those claims, are themselves defamatory and purposely brought by plaintiff and her counsel to systematically deprive defendant of her constitutional rights to free speech and due process. See, that's see answer and counterclaim. Certain of defendant's counterclaims reflect these beliefs: first, second, third, fourth, fifth, eighth, and ninth counterclaims, alongside related counterclaims for malicious prosecution and intentional infliction of emotional distress, sixth, seventh, 10th, and 11th counterclaims. Together, these counterclaims presume and depend upon an alternate version of events surrounding the murder of the 4 University of Idaho students, namely that plaintiff orchestrated the murders and then colluded with her counsel to bring this action against defendant to silence her clairvoyant insight into the true extent of plaintiff's involvement. I mean, let's pretend for a moment. Let's pretend that Ashley Guillard is clairvoyant. Bringing a lawsuit, I wouldn't think would be capable of silencing her clairvoyance. It just stops her from speaking it aloud in public, from publishing. It doesn't work. I would think in order to silence her clairvoyance, you've got to put her in a Faraday cage, or a frontal lobotomy or something. I don't know what, but steal her tarot cards. Something like that would be what would silence her legitimate clairvoyance. The lawsuit's just seeking to get her to shut up. That's all this is. It's shut up, keep my name out of your mouth, don't talk about me, don't publish defamatory statements about me. Her clairvoyance, or lack thereof, is irrelevant. They don't care. They just want her to stop talking about Professor Scofield. That's it. I wonder if I mean, this is obviously civil, not criminal. I wonder to what extent an old school jail cell would serve as a Faraday cage. I don't think it's enough. But those are things I think about. So the problem with this theory, however, is that there is no objective basis to believe that plaintiff did the things that defendant publicly and repeatedly claims she did. Defendant insists that her intuitive abilities, spiritual acuity, and investigative skills into the murders led her to plaintiff. Specifically, she claims that during her spiritual research, she was intuitively led to the University of Idaho History Department and spiritually inquired into each person listed on the History Department's webpage, seeking their role in the murders. As defendant describes it, the insight into plaintiff in particular revealed that she was in a relationship with one of the victims that broke up, and that she initiated the murders, planned the murders, and hired help to carry the plan out. The results of defendant's spiritual investigation represent the only support for defendant's belief that plaintiff masterminded the murders, and, correspondingly, the only justification for defendant's counterclaims against her. Significantly, only defendant has these opinions about plaintiff. The court is unaware of similar claims from any other sources, or the existence of any independent evidence remotely suggesting the same. When pressed for corroboration during oral argument, defendant merely responded that she believed her allegations about plaintiff were true, and that with discovery, she can find evidence that bears this out. Once again, that's a fishing expedition. Defendant also claimed that plaintiff, as a professor at the University of Idaho, possibly knew the deceased students and was involved in their murders. Without more, these explanations do not support a plausible claim for relief under Twombly and Iqbal. And we've got footnote 3. Defendant further stated that plaintiff could have been involved in the murders because similar murders had taken place at the University of Idaho in the past. But defendant was unable to recall the particulars of this claim before ultimately agreeing that it was not relevant to the instant action. But, Your Honor, it's happened before by other people, so it could have happened here. Ted Bundy murdered a bunch of people in the past, so, you know, this random person might have done the same. Frankly, it's offensive. To begin, defendant cannot use discovery as a fishing expedition to find facts that might validate her claims. This ready, fire, aim. I told you the court had a good analogy for the fishing expedition. Ready, fire, aim. This ready, fire, aim approach is not permitted under the federal rules of civil procedure. Moreover, on a motion to dismiss, courts generally may not consider materials, including discovery, other than a complaint's allegations and documents made part of that complaint. So basically, on a motion to dismiss, the only factual allegations that can be considered are in the complaint. That's it. It's only what's in the complaint or in the materials, the documents made part of that complaint. So if there are exhibits as part of the complaint, if there are affidavits as part of the complaint, but nothing else. So discovery can't save a deficient complaint. Of course, if discovery has found something, let's say for some reason you open discovery and you've provided discovery before the motion to dismiss has been ruled on, and you receive as part of that discovery facts that actually do support your claims, it can't make your claim survive the motion to dismiss. But assuming that it hasn't been dismissed with prejudice, you can then refile, also assuming it hasn't gone past the statute of limitations. But you refile with what you got in that initial discovery, and hey, suddenly you have facts. And even though this has been dismissed with prejudice, you'll see that the court is throwing her a bone. And it's basically, let's say you had received some discovery that would have made it survive a motion to dismiss, but it was dismissed with prejudice. You know, you can appeal that, or do a motion to reconsider and saying, hey, judge, I have the facts now, so refiling wouldn't be futile. So please, can I have another bite at the apple? And the judge has basically said, hey, this is spoiler for later on, but the judge has said, hey, you're going to get discovery because Professor Scofield's claims are still active. They're still alive. And let's say that in discovery for the professor's claims, you get evidence that she's a murderer. Then I'll scratch out that with prejudice part and you can bring the claims again. Easy peasy. Okay, and before my tangent, so as far as the four corners of the complaint, that's Anderson versus Angelone, Ninth Circuit, 1996. In short, the pleading requirement does not provide a key to unlock the doors of discovery for a plaintiff armed with nothing more than conclusions. Again, a complaint must be plausible on its face. That's Iqbal once again. And see also Stevens versus St. Francis Medical Center, Central District of California, 2018, which says, to the extent plaintiffs contend that the action should not be dismissed until they can conduct discovery, they are incorrect. Plaintiffs are not entitled to discovery based on a complaint that cannot survive a motion to dismiss. More to the point, defendant does not present to the court in either her answer and counterclaims or her response to plaintiff's motion to dismiss a factual account that would allow the court to infer the existence of a plausible claim against plaintiff. Instead, based solely on her claimed ability to psychically divine the truth, defendant makes extraordinary allegations about how plaintiff orchestrated the murder of 4 people to cover up a secret romantic relationship with one of the victims. These claims are not only conclusory and unverifiable, but are arguably so outrageous as to be clearly baseless and thus implausible. I'm going to say that again. They're so outrageous as to be clearly baseless and thus implausible. The court ain't buying it. Because the predicate components to defendant's counterclaims against plaintiff lack any basis in fact, those counterclaims should not proceed. So it's not just that they lack sufficient basis in fact, they lack any basis in fact. So it's not just basically what are the elements of defamation? You have to have said something. I'm terrible at giving the elements of a cause of action if I don't have it right in front of me, so I'm paraphrasing. But you have to have said something untrue about someone that was published and it was caused damages, and in some cases it has to be with malice, and that's for defamation per se or for a public figure. So let's say you've argued sufficient facts for 2 of the elements. You said something and it was damaging. And let's say it's even said with malice, but it wasn't published. If I'm sitting in my room at home and I say aloud, if I say this person did this abominable thing, but no one was around to hear it. I said it. I did all of the other things. And if somehow it got out to, if Professor or if Ashley Guillard somehow through her spiritual acuity found that out and she pled those facts, and I can't deny it. I'll say, hey, yeah, I said those. I said those. I don't know how she knows, if she has my room bugged, if she's psychic, but I said those. So that meets several of the elements of defamation. But I did not publish those. I said those in the privacy of my bedroom when I was alone. There was no one within earshot. I never wrote it down. Nothing. It was not published. And, psychics astral projecting into my room does not count as publication. So that would be, it lacks sufficient factual basis, because there are facts, but it's insufficient facts to survive a motion to dismiss, because they fail on one element, publication. But here, it lacks any basis in fact. It's not, she's missing one element, she's missing all elements. Well, I mean, I guess kind of publication, although other than the press conference, responding to press requests, suing isn't publication. It doesn't count as publication. So, either way, it lacks any basis in fact, and so those counterclaims should not proceed. Additionally, defendant attributes the conduct of plaintiff's counsel to plaintiff based upon a perceived conspiracy between them, but she offers no basis for concerted action. She simply assumes its existence throughout her answer and counterclaims when alleging that, together, plaintiff and her counsel conspired to harm her. And this is a long list of all the places she makes that conclusion. Reflexively, lumping plaintiff and her counsel together without distinguishing their conduct, if any, in any way, fails to satisfy Rule 8. That's citing Dana versus Tewalt, District of Idaho, 2022, which says, it is particularly important that the complaint make clear exactly who is alleged to have done what to whom, to provide each individual with fair notice as to the basis of the claims against him or her. That's quoting Robbins versus Oklahoma, 10th Circuit, 2008. This is particularly problematic when, under Idaho law, claims of conspiracy must be pled with specificity. That's Kerr versus Recon Trust Co., Idaho Court of Appeals, 2014, which says, there must be specific evidence of a plan or agreement to demonstrate the existence of a conspiracy at the time the allegedly unlawful objective was accomplished. At bottom, the court struggles to accept defendant's allegations as creating factually plausible counterclaims against plaintiff. This alone would justify granting plaintiff's motion to dismiss. But defendant's counterclaims are also legally deficient and therefore separately subject to dismissal for failing to state a claim upon which relief can be granted. And I'm going to harp on it again. Remember the motion for sanctions. They are factually deficient and legally deficient. Or, well, I think she said they are factually implausible and legally deficient, and they're pled in such bad faith that, hey, you should sanction her. But since at this time attorney's fees weren't granted, I doubt, even though the motion for sanctions hasn't been responded to, even though it's been more than 21 days, I think the court is unlikely to grant the sanctions at this time. So each of defendant's counterclaims against plaintiff is also legally deficient. And let me know in the comments, how many of these, the court's conclusions here, how many of them are exactly what I have said in the past? Or, almost exact. Defendant asserts 2 defamation counterclaims against plaintiff. Both cite to 28 USC section 4101, except Section 4101 does not create a private right of action. It is instead the definitions section of the Securing the Protection of Our Enduring and Established Constitutional Heritage Speech Act. I hate cleverly titled statutes to make the Speech Act, or like the one we had to do a lot in my securities law classes, the Jobs Act, which I can't remember what that stands for, but it was basically about unregistered securities. So if you've invested through Indiegogo, that's probably allowed under the Jobs Act, since it's probably not a Reg D security, and it's certainly not a public security. It's a private security. So, but that's way beyond. But the Speech Act, which protects a citizen from foreign defamation judgments. See 28 U.S.C. Section 4102. Defendant is not trying to enforce a foreign defamation judgment here. Therefore, the Speech Act does not apply, and defendants misguided first and second counterclaims based on Section 4101 are without merit. See Gonsalves versus Withy, District of Hawaii, 2022. That's a bit of irony there, that she's citing to a Gonsalves case, since one of the victims was Kaylee Gonsalves. That's a bit, yeah. But that's exactly what I said, though, isn't it? It's a definitions section about what kind of judgments for defamation can be enforced in federal court. It's not a cause of action. The court agrees with me. Exactly. And remember, in her opposition to the 12b-6, Guillard said, well, yeah, it was inartfully pled, but I pled all the elements of a common law defamation action. So even though I pled the wrong statute, which I shouldn't have pled a statute at all, you shouldn't throw it out because the elements are there, even though they're all conclusory and fanciful and factually deficient, but it's legally sufficient, so it should survive. The court obviously disagrees, because 4101 is what was in the complaint, the counter complaint, I should say. And since you can only go based on the four corners of the complaint, so her arguments that, well, yeah, but I really meant to plead the common law, that's not in the complaint, so it doesn't count. Even if the court liberally interpreted defendant's answer and counterclaims to allege defamation counterclaims against plaintiff under Idaho state law, those counterclaims would still fail. As a threshold matter, plaintiff never made the statements to the media about which defendant complains in her first counterclaim. Only plaintiff's counsel did. There is no basis to hold plaintiff responsible for statements she never made. See Clark versus the Spokesman Review, Idaho Supreme Court 2007, which says, in a defamation action, the plaintiff must prove that the defendant communicated information concerning the plaintiff to others. See also Supra, no evidence of conspiracy between plaintiff and her counsel. I wonder if Johnny Depp wishes he had sued in Idaho. Not that Idaho had jurisdiction in his case, but the Adam Waldman statement that Johnny Depp was held liable for, even though it probably wasn't even defamatory in the first place, but it certainly wasn't uttered by Johnny. It was his attorney. At least under Idaho law, you know, Idaho, of course, is not Virginia, but under Idaho law, that wouldn't have survived the motion to dismiss. I really regret not live streaming the Johnny Depp trial. I remember when it started, and Law Talk with Mike first day said, yeah, I'm going to be on Legal Bites. I don't really care about the trial, but I've been invited. I'm going to go join. I had the same thought. I hadn't been invited onto Legal Bites, although my understanding is that Legal Bites and Ricada and a few others were kind of like, yeah, if you're an attorney with a YouTube channel, jump on. I really didn't care about the Johnny Depp trial, and so I didn't do it, and I really wish I had, because yeah, we all saw what it became. Further, Idaho's judicial privilege forecloses defendant's second counterclaim. The judicial privilege immunizes a party from civil liability for statements made in the course of judicial proceedings. See Berrien versus Berberian, Idaho 2020. Hey, that's the same case that I've kind of snickered at, Berrien versus Berberian. Same case cited by Professor Scofield. That says, Idaho has long recognized that defamatory statements made in the course of a judicial proceeding are absolutely privileged, even if made with malicious intent or knowledge of their falsity. The purpose of the judicial privilege is to keep the paths leading to the ascertainment of truth as free and unobstructed as possible. This privilege sets a low bar, requiring only that the defamatory statement, 1, be made in the course of a proceeding, and 2, have a reasonable relation to the cause of action of that proceeding. That's citing Dickinson Frozen Foods, Inc. versus J.R. Simplot Co., Idaho 2019. Plaintiff's complaint and the allegedly defamatory statements made therein easily meet the standard. In footnote 4, the court takes no position here as to whether plaintiff's counsel's statements to the media after plaintiff initiated this action are similarly privileged. Regardless, again, plaintiff did not make these statements, and there is no basis to hold plaintiff responsible for statements made by her counsel. So the court is basically saying, hey, you can try, Ashley Guillard, you can try to sue plaintiff's counsel based on this, which I'm not making a ruling on because, I'm not making a ruling on whether the privilege extends to it, because I don't even have to get that far, because you're not even alleging that the plaintiff spoke it. You're making these allegations against the attorney who is not a party to this case. So it is moot. It is not ripe for a decision. It's irrelevant. It will only be ripe, unmoot, if you properly sue the attorneys. And then I'll make the decision. But that decision is not going to be in Ashley Guillard's favor. Why? Because let's look at the factors again. It be made in the course of a proceeding, so proceeding meaning lawsuit, and have a reasonable relation to the cause of action of that proceeding. You'll notice it doesn't say it has to be said in court, in a court filing. It's in the course of a proceeding. Statements to the media about the case, based on my reading of these two factors, count. They're privileged. So she can try suing the attorneys for this one thing. Well, I mean, she can try suing the attorneys for all of them, but, you know, she would absolutely be sanctioned for those because she's already received a bench slap over them. But for this one that the court has not ruled on, she can try, but she's going to fail. So why try? As Homer Simpson wisely said, "Well, son, you tried and you failed. The lesson here is never try." Homer Simpson is more of a sage than Ashley Guillard. But as such, defendants' first and second counterclaims fail to state a defamation claim against plaintiff. B. Defendants 42 U.S.C. Section 1985 2 obstructing justice conspiracy claims, third and eighth counterclaims. Defendant alleges 2 counterclaims under 42 U.S.C. Section 1985 2. Even though in her opposition to the motion to dismiss, she kept referring to Section 3 of 1985, which she hasn't pled as a cause of action. So why did she keep alluding to it? I don't know. But either way, she asserts that plaintiff conspired with her counsel to interfere with defendant's right to due process and freedom of speech by suing defendant for defamation in what she believes is the wrong venue. Section 1985-2 proscribes conspiracies that interfere with civil rights, permitting a civil action for damages based on the following circumstances. If 2 or more persons in any state or territory conspire to deter by force, intimidation, or threat, I mean, suing wouldn't be force or a threat, and I don't think it would be intimidation either, but either way, any party or witness in any court of the United States from attending such court or from testifying to any matter pending therein freely, fully, and truthfully, or to injure such party or witness in his person or property on account of his having so attended or testified, or to influence the verdict, presentment, or indictment of any grand or petit jury in any such court, or to injure such juror in his person or property on account of any verdict, presentment, or indictment lawfully assented to by him, or of his being or having been such juror, or if 2 or more persons conspire for the purpose of impeding, hindering, obstructing, or defeating in any manner the due course of justice in any state or territory, with intent to deny to any citizen the equal protection of the laws, or to injure him or his property for lawfully enforcing or attempting to enforce the right of any person or class of persons to the equal protection of laws. That's 42 U.S.C. Section 1985, sub 2 in its entirety. And what's funny in reading that, I noticed something that I didn't in the previous readings of it. You'll notice it says a couple times to influence the verdict, presentment, or indictment of any grand or petit jury. What I noticed, presentment. Why is that relevant here? Why did I notice that? Now, it's a case I'm not covering. At least I haven't been covering. But it's a related case. Go watch Emily Baker, Lawyer You Know, I think Law and Lumber's covering it. Hell, everyone's covering it but me, it seems. But Brian Koberger, he's trying to get the indictment dismissed, and his attorneys have argued this isn't a proper indictment under the standard they brought. This is just a presentment, so you've still got to go to preliminary hearing to sustain charges under a presentment, because an indictment has to be, the jury has to be instructed that an indictment has to be beyond reasonable doubt. Probable cause is just a presentment. I think that's a wrong reading, but it's an argument that Koberger's attorneys have made relatively recently. The judge hasn't even ruled on it yet. So I just, in rereading Section 1985, it kind of amuses me that they include a presentment in it. So, read in its entirety, Section 1985-2 consists of two distinct parts that give rise to separate causes of action, citing Bagley versus CMC Real Estate Corporation, 9th Circuit, 1991. The first part protects parties and witnesses from conspiracies to deter them from attending or testifying in court proceedings. The second part protects parties from conspiracies which obstruct the due course of justice with intent to deny equal protection. Defendants, Section 1985-2, related counterclaims against plaintiff satisfy neither of these parts. First, and most obviously problematic, there is no plausible claim of any conspiracy involving plaintiff that would implicate Section 1985-2 twin protections. Because once again, she hasn't properly pled a conspiracy. To be actionable, the conspiracy must result in overt acts done in furtherance of the conspiracy that are both the cause in fact and proximate cause of a plaintiff's injuries. A mere allegation of conspiracy without factual specificity is insufficient to support a claim. That's Sanchez versus City of Santa Ana, 9th Circuit, 1990. Here, plaintiff's only connection to a possible conspiracy to interfere with defendant's civil rights is through her relationship with counsel. That is not enough to support a Section 1985-2 conspiracy claim under either of its parts. See also Faris versus Scherer, 11th Circuit, 2003, which says, as long as an attorney's conduct falls within the scope of the representation of his client, such conduct is immune from an allegation of a Section 1985 conspiracy. So basically, it's taking that away from a 1985 claim. If I'm defending someone accused of murder, I'm not conspiring in the murder. I'm defending them in court. I'm only conspiring if I do it before the murder happened and I say, well, it would really help my defense later if you dumped the murder weapon and it couldn't be found. Then I've got some liability. Is it conspiracy to commit murder? Is it conspiracy to obstruct justice? Conspiracy into tampering with physical evidence? Maybe. But I probably have some liability in that case. But if I'm in court and I say, hey, the weapon can't be found, there is no evidence that my client ever had that weapon, you must acquit. That's not conspiracy. That's representing my client in court. And see also Petrisevich versus Shin, District of Hawaii, 2021. It is not possible for the motion defendants as attorneys to have conspired with their clients for purposes of a Section 1985-2 claim because their alleged conduct occurred within the scope of representing their clients. Second, defendant does not allege that she is or was a party, witness, or juror in any underlying action impacted by plaintiff's alleged conduct. That's exactly what I said. It's almost like attorneys kind of know what they're talking about on occasion. She's not a party. Her name is not Brian Koberger or the state of Idaho. She's not a witness. She wasn't there. She's never been to Idaho. And she's not a potential witness. There's no indication whatsoever, and she hasn't pled any evidence of this. She hasn't pled that, hey, I've been talking with the Latah County District Attorney and they intend to call me as a witness. There's none of that. She's not a witness. She's not going to be in court at all unless she's in the gallery as a spectator for the Brian Koberger trial. She, as far as that case is concerned, she doesn't exist. And she's certainly not going to be a juror because she's a resident of the state of Texas. She is not in the potential juror pool at all. Not only is she not a juror, she can't possibly be part of the juror pool. I mean, she could move to Idaho, I guess, before the trial, although if the trial goes ahead in October, could she establish residency in time? I doubt it, but either way, let's say she becomes a juror down the line because she moves to Idaho to try to become a juror. One thing I've noticed, the only 2 juror summons I've ever received have been after updating my voter registration. So I don't know. I've never been involved as a court clerk sending out juror summons, but I think they do, at least in Utah. If there's some indication that you're newish, you get to the top of the list somehow. That might just, that just might be me based on my, body of evidence of 2. But either way, let's say she becomes a juror because she does move to Idaho. It wasn't foreseeable that she'd be a juror, but even still, she's not suing her to stop her from being a juror. She's suing to stop her, to keep her name out of Ashley Guillard's mouth. So, and that says, see Head versus Wilkie, 9th Circuit 2019, which explains that parties and witnesses to an action where they claim to have been intimidated or retaliated against have standing to bring a claim under Section 1985-2. The only conceivable legal proceeding defendant could invoke is the criminal prosecution of Brian Koberger in Latah County, Idaho. Aside from her claimed psychic abilities into the events surrounding Mr. Koberger's upcoming trial, defendant is not involved in that case, nor can she demonstrate any obstruction of justice in that case due to plaintiff's alleged conduct. Owing to this separate omission, defendant fails to state a claim under the first part of Section 1985, sub 2. Footnote 5. Defendant concedes that she is not involved in any separate action which undermines a claim based on the first part of Section 1985-2. Defendant has not claimed to be a party to Mr. Kohberger's case. Plaintiff's argument is moot. And that's a direct quote from Ashley Guillard's opposition to the motion to dismiss. You may remember, I lost my mind at this. It's defendant has not claimed to be a party to Mr. Kohberger's case. Therefore, her argument is moot. No. This cause of action is moot, is irrelevant, is not properly pled, specifically because you are not a party to Mr. Kohberger's case. It's the other way around. This might be why I fell behind on this case and decided to skip over the missed pleadings and go straight to this decision, because Ashley Guillard makes my head explode. Third, the second part of Section 1985-2 requires an allegation of a class-based, invidiously discriminatory animus behind the conspirator's actions. That's Phillips versus International Association of Bridge Workers, 9th Circuit, 1977. And remember when I said that there has to be a discriminatory animus. I remember talking about that when the answer and counterclaims were first made, when they were first filed. That they weren't made for a discriminatory purpose. I mean, Guillard might claim, well, she's discriminating against psychics. But psychics are not a protected class. She may argue, well, it's part of my religion. She has argued that, in fact. She's not being targeted because of her religion. She's being targeted because of the words she has said. And see also Bretz versus Kelman, 9th Circuit, 1985, which says, we read the equal protection language of the second clause of Section 1985-2 to require an allegation of class-based animus for the statement of a claim under that clause. So, like, Ashley Guillard is an African American. She's Black. That is a protected class, race. If she could allege somehow that Professor Scofield brought these claims based on Ashley Guillard's race, that would help. Of course, it still doesn't help that she's not. Let's scroll back up. Let's scroll back up, mark where we are, and scroll back up. So, or if two or more persons conspire for the purpose of impeding, hindering, obstructing, or defeating in any manner the due course of justice in any state or territory, with intent to deny to any citizen the equal protection of the laws, or to injure him or his property for lawfully enforcing or attempting to enforce the right of any person or class of persons to the equal protection of laws. So even if, let's say, Professor Scofield would have allowed a white person to make these claims without suing them, and she only sued because she was defamed by an African American. Let's pretend that that's the case. I don't know why it would be the case, but let's pretend that's the case. Ashley Guillard was still not denied the rights to equal protection of laws. It wasn't to injure her or her property from lawfully enforcing or attempting to enforce the right of any person or class of persons. Because once again, she was not involved in any case. She's being sued for defamation. That's it. 1985 wouldn't apply even if it was brought for racial reasons, which it wasn't. But even if it was, it wouldn't count. All right, there we are. A defendant fails to allege any facts supporting the conclusion that plaintiff's complaint was motivated by invidiously discriminatory class-based animus. Indeed, there is no allegation of such motivation at all. And footnote 6 is a long one, so you know if a footnote is this long that the judge really has feelings. So, though not a part of defendant's allegations against plaintiff, defendant's briefing on the subject attempts to equate her spirituality with a protected religious class. Plaintiff vehemently asked the court to decide that spiritual practices, and this is quoting from the opposition to the motion to dismiss, plaintiff vehemently asked the court to decide that spiritual practices as in tarot readings and spiritual connections as in mediumship and psychic intuition are implausible, ergo seeking that the court discriminate against defendant based on her spiritual practices. End of quote. But this misstates plaintiff's claims against defendant. Plaintiff's complaint cannot be read as an attack on defendant's spirituality, but on defendant's false claim that plaintiff murdered 4 people. Defendant's spirituality is immaterial to this claim. In any event, while it is possible that defendant's psychic abilities relate to an unknown religious practice for the purposes of the second part of Section 1985-2, it is also possible that it relates to a purely secular pursuit untethered to a protected class, e.g., a type of philosophy. See El Shaddai versus Stainer, Central District of California, 2016. Thus, it can be argued that defendant may not rely on such allegations to plausibly show that her spirituality ipso facto amounts to protected religious practices vis-a-vis her Section 1985A claim. But she didn't bring a Section 1985 claim. And citing In Re Century Aluminum Co., I assume, versus Sacklidig, 9th Circuit, 2013, which says, when allegations in a complaint are consistent with 2 possible but contradictory inferences, only one of which can be true and only one of which results in liability, plaintiffs may not rely on allegations that are merely consistent with their favored explanation, but are also consistent with the alternative inference to render their allegations plausible within the meaning of Iqbal and Twombly, but instead must allege something more, such as facts tending to exclude the possibility that the alternative explanation is true. So basically what that's saying is, let's say I'm charged with a hate crime. I have murdered a Black person. That I have been charged with a hate crime enhancement. But they still have to show that I specifically committed the murder because that person was Black. If it's equally likely that I killed that person because they were a masked intruder breaking into my home and I was defending my property. They, you know, if somehow those are equally plausible, they still have to show, hey, it was because he hates black people and he's been wanting to murder a black person all his life. This is all obviously just for the purposes of a hypothetical. I would never do that, but they still have to prove that hate crime enhancement. Here, if it's equally plausible that Professor Scofield is, or it's not equally plausible, but if one reading can be Professor Scofield is suing to impact Ashley Guillard's spiritual practice, or she's suing to stop her from defaming Professor Scofield. Both of those are possibilities. Well, you've got to bring facts that it's to stop her spiritual practice. You haven't brought any facts that that's the purpose. So it's unpled. So even though that might be a result of this litigation, it's unpled. It's irrelevant. It's a side effect. She's sued to stop defamation. That's the plausible alternative. That was a long footnote. Plaintiff's defamation claims against defendant follow plaintiff's straightforward contention that defendant purposely communicated false statements about her to the public. Nothing more, nothing less. Absent a class-based, invidiously discriminatory animus for plaintiff's complaint, defendant fails to state a claim under the second part of Section 1985-2. Fourth, the due course of justice contemplated by the second part of Section 1985-2 does not include First Amendment protection for false statements of fact. In Idaho, only statements of opinion enjoy constitutional protection. False statements of fact are actionable. And that's Elliott versus Murdoch, Idaho 2016. Plaintiff's defamation claims against defendant implicate this distinction, but they do not give rise to an affirmative Section 1985-2 counterclaim, nor does defendant's belief that plaintiff brought her claims in the wrong venue. Rather than bring a Section 1985-2 claim, defendant could have challenged plaintiff's complaint for improper venue in accordance with Rule 12b-3. And footnote 7, when venue is improper, the case must be dismissed or transferred under 28 U.S.C. Section 1406A. A Marine Construction Company, Inc. versus U.S. District Court for the Western District of Texas, Supreme Court 2013. But see 28 U.S.C. Section 1406B. Nothing in this chapter shall impair the jurisdiction of a district court of any matter involving a party who does not interpose timely and sufficient objection to the venue. So it's use it or lose it. You brought a counterclaim saying your rights were violated due to this being the wrong venue, but that's just the wrong way to do this. You should have brought a 12b-3 improper venue motion, and it could have been dismissed for that or transferred. But that's not a cause of action. You brought it as a wrong cause of action, as a made up cause of action. but made-up causes of action fail. You waived your 12b3 motion because, well, you waived a 12b3 motion because you did not bring a 12b3 motion. But you also waived a 12b3 motion by bringing counterclaims and asserting that Idaho is the right jurisdiction to hear those counterclaims. You assented to the jurisdiction of the District of Idaho to hear this case. Your rights were not violated. You assented to jurisdiction. You demanded this jurisdiction in your counterclaims because they've got to be brought in the same case. You can't have competing cases going on in Idaho for your counterclaims and in Texas for the initial claims. It doesn't work that way. In sum, each of defendants' Section 1985-2 claims fail because she has not plausibly alleged the existence of a conspiracy involving plaintiff to violate her civil rights. Defendant also fails to state a claim under the first part of Section 1985-2 because she has not alleged a proceeding from which plaintiff's conduct deterred her participation. Finally, defendant's claim under the second part of Section 1985-2 fails because she has not alleged invidiously discriminatory class-based animus. Accordingly, defendants' third and eighth counterclaims fail to state a claim against plaintiff for conspiring to interfere with defendant's civil rights in violation of Section 1985-2. Next, defendants' 42 U.S.C. Section 1986 action for neglect to prevent claims. Defendant brings counterclaims for failure to act or protect in violation of 42 U.S.C. Section 1986. Section 1986 provides a cause of action against anyone who has knowledge that any of the wrongs conspired to be done and mentioned in Section 1985 of this title are about to be committed, and having the power to prevent or aid in preventing the commission of the same neglects or refuses to do so. That's citing Park versus City of Atlanta, 11th Circuit, 1997, which quotes Section 1986. Section 1986 claims are therefore derivative of Section 1985 violations because the text of Section 1986 requires the existence of a 1985 conspiracy. And see also McCalden versus California Library Association, 9th Circuit, 1990. So basically, a valid Section 1985 claim is a condition precedent to bringing a Section 1986 claim. If there is no Section 1985 claim, there is no Section 1986 claim. As there are no Section 1985 claims here, the court must dismiss the Section 1986 claims, as I discussed in previous videos. Here, because there are insufficient facts to establish a predicate Section 1985-2 violation, it necessarily follows that there are insufficient facts to establish a Section 1986 violation as well. Therefore, defendant's fourth and ninth counterclaims fail to state a claim against plaintiff for not preventing a conspiracy to interfere with defendant's civil rights in violation of Section 1986. Next, defendant's 42 U.S.C. Section 1983 deprivation of rights claim, fifth counterclaim. Consistent with the other counterclaims already discussed, defendant alleges a counterclaim under 42 U.S.C. Section 1983. Section 1983 creates a species of tort liability. I like that. Species of tort liability for the deprivation of any rights, privileges, or immunities secured by the Constitution. That's citing Manuel versus City of Joliet, Illinois, Supreme Court, 2017. I believe that's the case that was cited by Professor Scofield in the motion to dismiss. Its purpose is to deter state actors from using the badge of their authority to deprive individuals of their federally guaranteed rights. That's McDade versus West, 9th Circuit 2000. To establish a Section 1983 liability, a plaintiff must show both 1. Deprivation of a right secured by the Constitution and laws of the United States, and 2. That the deprivation was committed by a person acting under the color of state law. That's citing Chudikoff versus University Medical Center of Southern Nevada, 9th Circuit, 9th Circuit 2011. Says a defendant acts under the color of state law when she abuses the position given to her by the state. Thus, generally, a public employee acts under color of state law while acting in her official capacity or while exercising her responsibilities pursuant to state law. That's West versus Atkins, Supreme Court 1988. See also Filarski versus Delia, Supreme Court 2012, which says anyone whose conduct is fairly attributable to the state can be sued as a state actor under Section 1983, quoting Lugar versus Edmondson Oil Co., Supreme Court 1982. So, in some circumstances, Professor Scofield is a state actor as a professor of the University of Idaho, a state institution. So, if she fails a student based on the color of their skin, she was acting under state law. Well, under the power of the state as a university professor to unlawfully, with racial animus, fail that student. That could probably sustain a Section 1983 claim. If she accuses a black student of cheating because they're black, and the University of Idaho expels that student based on that false accusation, that probably sustains a Section 1983 claim because she's a state actor. Her suing for defamation, she's not a state actor. So 1983 is irrelevant. Let's see what the court says. While plaintiff is a professor at the University of Idaho, her defamation claims against defendant exist independent of that status. Plaintiff raises those claims not as a state actor or while acting under color of state law. Instead, she raises them as a private citizen, acting in a private capacity, completely unrelated to her duties as a college professor. Therefore, defendant's fifth counterclaim fails to state a Section 1983 claim against plaintiff. How many times have I said that in the past? For the purposes of this lawsuit, she is not a state actor. Ashley Guillard tried to say, well, you're suing me in a federal court, which is a function of the state. The state not being the state of Idaho, but the United States. You're imposing the power of the government against me by dragging me into court. Therefore, you're a state actor. But that's not how it works. And let's see what footnote 8 says. Alleging that plaintiff raises her defamation claims pursuant to state law and filed a police report for defamation against defendant pursuant to Idaho Code, defendant argues that plaintiff is in fact acting as a state actor and or under color of state law. Case law, however, does not support such a legal reach. Otherwise, any claim for defamation would automatically support a Section 1983 claim, an absurd result. I didn't read footnote 8 before I said exactly that just a minute before. It's almost like all of Ashley Guillard's arguments have been absurd, and me responding to them, it's the same as the court's responses. So I don't like the formatting here, but that's irrelevant. Next up, we have defendant's malicious prosecution, frivolous claims. 6th and 7th counterclaims. Defendant considers plaintiff's defamation claims against her frivolous and de facto evidence of an improper malicious prosecution under Idaho law. Malicious prosecution actions and actions for the tort of wrongful civil proceedings are disfavored and are limited by requiring a plaintiff to establish several elements, citing Battle versus Beeks, Idaho, 1988. A plaintiff must prove 1. That there was a prosecution, 2. That it terminated in favor of the plaintiff, 3. That the defendant was the prosecutor, 4. Malice, 5. Lack of probable cause, and 6. Damages. That's citing Rinkover versus State, Idaho, 1996. Defendant cannot plausibly allege these elements. Critically, there has been no prior prosecution to this point. Only this standalone action, still in its very beginning stages. We're at the motion to dismiss stage. We haven't even seen discovery, really. I mean, they have already had the Rule 26 discovery meeting, and Professor Scofield's proposed discovery plan has been accepted and controls. And as we'll see, there have been some discovery requests, but it's still early. So a malicious prosecution claim depends on an earlier action from which the claim can be rooted and reviewed. CEG, CNA, CNA CAS of California versus Seaboard Surety Company, California Court of Appeals, 1986, which recognizes in coverage context that malicious prosecution claim under California law requires prior termination of an earlier proceeding. Without the requisite earlier action, a malicious prosecution claim collapses because its elements cannot exist as a matter of law. E.g., it would be impossible to allege that a non-existent earlier action was ever terminated in defendant's favor. Footnote 9. Therefore, defendant's 6th and 7th counterclaims fail to state a claim for malicious prosecution against plaintiff. And footnote 9 is another nice long one. Defendant responds that, while plaintiff's defamation claims have not yet been terminated in defendant's favor, Rule 18 still permits her malicious prosecution counterclaim because it is contingent on the favorable resolution of plaintiff's defamation claims. Defendant misunderstands Rule 18. Rule 18b allows a party to join two claims even though one of them is contingent on the disposition of the other, Federal Rule of Civil Procedure 18b. As an example, Rule 18b provides a plaintiff may state a claim for money and a claim to set aside a conveyance that is fraudulent as to the plaintiff without first obtaining a judgment for the money. So basically, the conveyance would be if I sold you land that I didn't own the title to. Well, if I sold you land, let's say, and it didn't have a clear title, and I paid you money, I can sue and I can say, hey, I want at least some of my money back, and I want a clear title to the land. That would be, they can state a claim for money and to set aside a conveyance. So in that case, it would be I sold you the land and you didn't pay me, but I'd already conveyed the land. I can say, hey, I want the land back. So undo the conveyance, set aside the conveyance of the land, and I want money damages for my troubles. So, defendant is not asserting contingent counterclaims under Rule 18b. Her malicious prosecution counterclaim depends on the resolution of plaintiff's underlying defamation claims, which have not yet been adjudicated. In other words, there has been no prosecution that can even be labeled as legally malicious. Exactly what I've said from the beginning. Exactly what Professor Scofield has said from the beginning. There being a previous litigation that has been resolved in your favor. So there has to be a previous lawsuit that was resolved in Ashley Guillard's favor, brought by Professor Scofield. That's a condition precedent for a malicious prosecution claim, because there is nothing that has been decided in Ashley Guillard's favor. There can be no malicious prosecution claim at this time. There won't be in the future either, because, you know, if this is dismissed, it'll be by consent because they reached a settlement. Otherwise, if it's brought to a jury, Professor Scofield's going to win. Let's see. Where was I? Another poorly formatted section heading. Next, we have defendant's intentional infliction of emotional distress claims, 10th and 11th counterclaims. We're almost there. Defendant alleges that plaintiff's defamation claims against her justify counterclaims for intentional infliction of emotional distress. And as I have often said, RICO is the legal equivalent of lupus. It's in the TV show House, it's never lupus. In law, it's never RICO, except those rare occasions that it is. And Ashley Guillard hasn't said RICO, but she's basically alleging civil RICO because she's trying to allege a conspiracy between Professor Scofield and the lawyers. But I've also said many times that intentional infliction of emotional distress is similar to RICO. It's not the legal equivalent of lupus, but it's the legal equivalent of an equally rare autoimmune disorder, because lupus is an autoimmune disorder. So, yeah. Defendant alleges, yeah, I already read that. To prevail on an intentional infliction of emotional distress claim, a plaintiff must show, 1, that the defendant acted intentionally or recklessly. 2, so negligence doesn't count, because that would, well, there wouldn't be a cause of action for negligent infliction of emotional distress if acting negligently sufficed. Since it's intentional infliction of emotional distress, you've got to act intentionally or recklessly. 2, that the defendant's conduct was extreme and outrageous. 3, that there was a causal connection between the defendant's conduct and the plaintiff's emotional distress. And 4, that the plaintiff's emotional distress was severe. That's citing Spence versus Howell, Idaho, 1985. Importantly, merely exercising a legal right does not satisfy the outrageousness element. To be actionable, the conduct must be so extreme as to arouse an average member of the community to resentment against the defendant, and must be more than unreasonable, unkind, or unfair. That's Mortensen versus Stewart, titled Guard Company, Guardianship, something, Guarantee Company. That's what it'll be. Idaho 2010, quoting 86 CJS torts, section 74, 2009. However, the actor is never liable where he has done no more than insist upon his legal rights in a permissible way, even though he is well aware that such insistence is certain to cause emotional distress. That's quoting Restatement Second of Torts, section 46, comment G from 1965. See also Edmondson versus Shearer Lumber Products, Idaho Supreme Court, 2003, finding no outrageous conduct where an employer was exercising a legal right to terminate an employee. So, yeah, getting fired sucks. Getting fired can cause great emotional distress. But your employer has the right to fire you in most circumstances. If they exercise that legal right to fire you, even though it caused you great emotional distress, it's not intentional infliction of emotional distress. The hypothetical I was thought of before continuing reading, where it said, you know, merely exercising a legal right does not satisfy the outrageousness element. So I was going to say, you know, the courts disfavor self-help. So if I'm a landlord and you're living in my property and have not paid me rent, if I go and I bust through the door, even though I have a key since I'm the landlord, and I chuck all your stuff out on the lawn and forcibly, you know, give you the bum's rush, throw you off the porch, slam the busted door in your face, and say you're evicted. Well, yeah, you're going to have a cause of action against me. Maybe not for an intentional infliction of emotional distress, but certainly for trespass, because, you know, unless you've been evicted, you have the right to exclude me from that property to the most part. So, but let's say I hire the sheriff to serve the eviction well, I already have the eviction order from the court, and I send the sheriff or the bailiff or whatever in that jurisdiction to evict you. And they throw your stuff out and give you the bum's rush and slam the door and say, you may not return. That was me exercising my legal right. You don't have a cause of action against me. So, defendant's disagreement. What? I'm getting ahead of myself here. Courts generally agree that merely exercising a legal right cannot itself constitute a tort, but that the defendant may nevertheless engage in extreme and outrageous behavior in the context of exercising a legal right. That's Restatement Third of Torts, Section 45, comment D from 2007. Defendant's disagreement with plaintiff's defamation claims and the backlash and resulting distress defendant alleges they caused does not give rise to a counterclaim for intentional infliction of emotional distress. Plaintiff is merely asserting her legal rights to redress what she believes were false public statements made by defendant about her. There is nothing objectively extreme or outrageous in doing so. Therefore, defendant's 10th and 11th counterclaims fail to state a claim for intentional infliction of emotional distress against plaintiff. Next, leave to amend would be futile. So that's why it's dismissed with prejudice. Defendant's counterclaims against plaintiff are dismissed because they are both factually implausible and legally deficient. And though Rule 15A2 instructs that courts should freely give leave to amend when justice so requires, leave may be withheld if the amendment is futile, citing Amerisource Bergen Corp., which was cited above. Defendants' counterclaims against plaintiff cannot be saved by an amendment. They are neither based in fact nor supported by the law. Given these serious deficiencies, allowing defendants leave to amend based upon the same legal theories and supported only by spiritual intuition would be futile. Defendants' counterclaims against plaintiff are therefore dismissed with prejudice. But we have footnote 10. The court's position in this respect applies only to defendants' affirmatively stated counterclaims against plaintiff. It should not be understood as a reflection of the court's position on either plaintiff's underlying claims or defendants' defenses thereto. Nor does it operate to preclude discovery relevant to these same claims and defenses to the extent permitted by federal rules of civil procedure. In the event such discovery reveals an evidentiary basis for legally supportable counterclaims against plaintiff that would render amendment not futile, defendant may move the court for leave to amend her answer to assert new counterclaims pursuant to Rule 15. So I mentioned that earlier. It's you can't go on a fishing expedition, you can't survive a motion to dismiss for failure to state a claim by saying, well, I think if you don't dismiss now, even though you should dismiss, even though you have a good cause to dismiss, but I think if you let me get to discovery, I'll be able to find some facts that mean you shouldn't dismiss now. I mean, she's a psychic, so she knows she'll find facts in discovery. But that's not how it works. But because it's the counterclaims being dismissed, she still gets discovery. Now, she only gets discovery relevant to defending Professor Scofield's claims. She can't go on a fishing expedition for irrelevant material to try to resurrect her zombie claims, her zombie counterclaims. But, there is some leeway. Who's to say what's irrelevant discovery? Who's to say what the scope and breadth of discovery is too wide? Well, I mean, we're going to see that in a minute, that they're arguing the meta subpoena is too broad. But if you get facts, in the unlikely event you find facts to support these claims, then you can ask the court to resurrect them, de-zombify them. It's unlikely. I don't see it happening. But hey, the court's saying, hey, yeah, you're going into discovery. If Professor Scofield if I was dismissing all the claims, then it would be with prejudice, because the reality is you're not going to find them anywhere. But you have this one limited avenue to find facts relevant to your claims, to support your claims. And if you find enough of them, hey, maybe. And as to the first part, they're saying, hey, yeah, as far as your counterclaims, I'm finding these facts implausible. I'm not saying you can't argue them as a defense. I'm not saying you can't argue them to the jury. The jury gets to decide if it finds these probable, if they pass muster. But, you know, Professor Scofield, that there might be motions in limine, there might be evidentiary motions to preclude some of these arguments, but the judge isn't precluding them now. Next up, an attorney's fees award against defendant is not warranted yet. Plaintiff requests the court exercise its inherent power to send a clear message to defendant for the rest of this litigation and award plaintiff her attorney's fees spent combating these frivolous counterclaims. And while the court isn't sending that message by granting it, he is sending a message for the rest of this litigation. And it's a very strong message. It's you have effed around. F around anymore and you will find out. It's saying we're at the top of the graph of F around and find out, and anything else is gonna tip it over the edge, and it's gonna be major finding out. Of course, he kind of sends the message to both sides, but only one of the sides has effed around. A district court may award sanctions in the form of attorney's fees against a party who acts in bad faith, vexatiously, wantonly, or for oppressive reasons. That's Leon versus IDX Systems Corp, 9th Circuit, 2006. Before awarding such sanctions, the court must make an express finding that the sanctioned party's behavior constituted or was tantamount to bad faith. A party demonstrates bad faith by delaying or disrupting the litigation or hampering enforcement of a court order. The bad faith requirement ensures that the district court's exercise of its broad power is properly restrained and preserves a balance between protecting the court's integrity and encouraging meritorious arguments. The court has previously remarked that certain of defendants' conduct after being served with plaintiff's complaint was off-putting and ill-advised. And that's from docket number 6. Or docket number 18. What was that? The memorandum decision order on defendant's motion to set aside entry of default. Without commenting here on the merits of plaintiff's complaint, defendant's answer and counterclaims unfortunately do nothing to allay these concerns. But it must be recognized that defendant is not an attorney, and with that, cannot be held to the same standards as an attorney when assessing whether she has acted in bad faith before this court. That's more or less saying, hey, if an attorney brought these frivolous, ridiculous arguments, yeah, there would be sanctions. There would be attorney's fees awarded. Whether Ashley Guillard or her attorney would be paying them, who knows? But someone would be paying them. But since she's pro se, we'll give her another chance. But this is the last chance. For this primary reason, the court declines to levy sanctions against defendant at this time. And it's not specifically saying the motion for sanctions is denied, but it might be. Additionally, the court cannot conclude with any confidence that defendant has purposely delayed or disrupted the litigation. Meritless counterclaims asserted by a non-attorney do not automatically rise to that level. But due to the very sensitive nature of this case and its impact to both litigants and non-litigants alike, that would be the families and friends of the 4 murder victims. They're not parties to this case. They are non-litigants. But they are deeply affected by this case. So, due to the very sensitive nature of this case and its impact to both litigants and non-litigants alike, the parties are on notice that the court's tolerance for any disregard for court procedure and basic decency is limited. With this in mind, the court's current refusal to assess sanctions against defendant does not foreclose the possibility that sanctions may be appropriate later. Until then, an attorney's fees award against defendant is not warranted. So that's denied for now. But if Ashley Guillard doesn't cooperate with the litigation, if she continues to assert frivolous claims, frivolous defenses, if she continues to inflict emotional distress on the families of the victims, if she continues to needlessly prolong this litigation, she could be on the hook for attorney's fees at the end. And so Professor Scofield was asking for attorney's fees for defending the meritless counterclaims. So at this stage, they were asking for only part of the attorney's fees for defending the counterclaims. At the end, they're going to ask for all of the attorney's fees, including for prosecuting their claims, for the professor's claims. And the court said right here, right now, F around and find out. If you put a foot out of line, you could find yourself on the hook for all of the attorney's fees. Don't try me. And that's a good time to remind you, there's a link down below for Professor Scofield's GoFundMe. Litigation is expensive. And finally, we have plaintiff's motion to quash. Defendant's answer and counterclaims assert the same above discussed counterclaims against plaintiff's counsel. To that end, the court issued summonses for plaintiff's counsel on June 8, 2023. Through her motion to quash, plaintiff requests that the court quash these summonses as procedurally deficient because they are not properly parties to the action under either Rule 13 or 14. The court agrees. Rule 13 addresses counterclaims. Defendant's counterclaims cannot be brought against plaintiff's counsel under Rule 13, A or B, because unlike plaintiff herself, plaintiff's counsel is not already a party to the action. See Federal Rule of Civil Procedure 13A and B, discussing compulsory and permissive counterclaims against an opposing party. Still, Rule 13H permits the joining of additional parties to counterclaims if warranted under Rules 19 and 20. See Rule 13H. Rules 19 and 20 govern the addition of a person as a party to a counterclaim. See also Rudder Group Practice Guide, Federal Civil Procedure Before Trial, paragraph 8, 1107, which says, although a counterclaim lies against lies only against an opposing party, the court may order joinder of additional parties whose presence would facilitate determination of the counterclaim necessary or proper parties under Rules 19 and 20. We've got footnote 11. But as we know from sovereign citizens, you can just say, I refuse to joinder, and that's it. Or, of course, in this case, you could say joinder is improper. Let's see what footnote 11 says. Rule 19 addresses the required joinder of party, while Rule 20 addresses the permissive joinder of party. Except Rule 13H applies only when counterclaims already exist against an opposing party. Counterclaims cannot be asserted entirely against third parties. See again, Rudder Group Practice Guide, which says, at least one of the parties to a counterclaim must be an opposing party. Even if there is subject matter relationship, a counterclaim cannot be asserted solely against new parties. See also 6 Wright and Miller, Federal Practice and Procedure, Civil, 3rd edition, section 1435. A counterclaim may not be directed solely against persons who are not already parties to the original action, but must involve at least one existing party. Here, with defendant's counterclaims against plaintiff now dismissed, there are no counterclaims against an existing party to anchor defendant's same counterclaims against plaintiff's counsel under Rule 13H. Therefore, any attempt to shoehorn defendant's counterclaims against plaintiff's counsel by following Rule 13H's discretion and joining plaintiff's counsel under Rules 19 and 20 is premature, if not outright improper. So, what the court, like I've said before, courts love deflecting. Remember when I discussed, what was it? Hollingsworth versus Perry. No. What was it? It was the California gay marriage case where the Supreme Court just said, yeah, we're not even going to discuss the right of gay marriage at this time because we're going to decide this based on the purported plaintiff didn't even have the right to intervene. So we're checking it for that reason. Here, the court's saying, well, yeah, you probably wouldn't have been able to join counsel anyway, but I'm not even going to get to that. I'm going to say you can't join them because there isn't a counterclaim in the first place to join them in. So, defendant does not appear to disagree, stating that she mistakenly referred to plaintiff's counsel as counter-defendants, but nonetheless followed the correct procedure to add them as third-party defendants under Rule 14. And footnote 12. Elsewhere in her briefing, defendant claims to assert joint and several liability between plaintiff and her counsel. To the extent this implicates Rule 20A to B, it is immaterial because plaintiff is no longer a counter-defendant. Once again, I'm not even going to decide that because there are no counter-defendants, because there has to be an existing counter-defendant to join any counter-defendants. But Rule 14 similarly does not permit defendants to add claims against plaintiff's counsel under the existing circumstances. Rule 14 speaks to third-party practice. Under Rule 14A, a defending party may, as third-party plaintiff, serve a summons and complaint on a non-party who is or may be liable to it for all or part of the claims against it. Federal Rule of Civil Procedure 14A. The objective of Rule 14 is to avoid the situation that arises when a defendant has been liable to plaintiff and then finds it necessary to bring a separate action against a third individual who may be liable for defendant for all or part of plaintiff's original claim. That's citing 6, Wright and Miller, Federal Practice and Procedure, Civil 3rd edition. So as an example of that, let's go back to Massachusetts for DeCastro versus Abrams. Delete Laws basically tried to argue this in his opposition to Google's motion to dismiss. Except he argued it poorly because, as the court says right here, really this was Kate and Josh's motion to argue, but Delete Laws, magnanimously argued it for them. It was, well, Google, the court shouldn't dismiss the claims against Google because if the court finds that Kate and Josh are liable for copyright infringement, well, Google, for not stopping them, might be liable, and it would be unfair to have Kate and Josh be liable for Google's portion of the damage. So you should just keep them in there for Kate and Josh's sake. That's basically what the court's saying here is, if Ashley Guillard had a spiritual mentor, let's say, if someone sold her a ineffective crystal ball, incomplete tarot deck that sent her to Professor Scofield instead of Brian Kohberger as the murderer. Well, Ashley Guillard, under Rule 14a, can drag in the purveyor of faulty crystal balls and say, hey, you caused me to commit this defamation, so you're at least partially responsible if I'm found liable. So you need to be a counter-defendant or a co-defendant or whatever. But it's not that this isn't the mechanism to say, hey, Professor Scofield had accomplices in defaming me. I need them to limit my liability. That's not how it works. Even a cursory review of Rule 14 reveals its inapplicability here. Plaintiff's counsel cannot conceivably be liable for the defamation claims plaintiff, their client, asserts against defendant. Said another way, for Rule 14 to theoretically apply, plaintiff's counsel would have to be responsible for defendants' allegedly defamatory TikTok videos about their own client. So the professors would have had to have sold Guillard the bad crystal ball. But they didn't, so it doesn't work. Such events are factually and temporally inconceivable. Defendants' counterclaims do not seek to redirect liability to plaintiff's counsel for plaintiff's defamation claims against defendant. Defendants' counterclaims prove this point. They allege separate and distinct defamatory conduct, albeit from plaintiff and her counsel, arising from plaintiff's complaint and plaintiff's counsel's comments to the media. Rule 14 does not apply to bring plaintiff's counsel into the case. Because plaintiff's counsel is not properly before the court as a party, The summonses issued for plaintiff's counsel will be quashed. Order. Based on the foregoing, it is hereby ordered that plaintiff's motion to dismiss defendant's counterclaim is granted in part and denied in part as follows. Defendant's counterclaims against plaintiff are dismissed with prejudice. In this respect, plaintiff's motion to dismiss defendant's counterclaims is granted. An attorney's fees award against defendant is not warranted at this time. In this respect, plaintiff's motion to dismiss defendant's counterclaims is denied. Plaintiff's motion to quash summonses for the attorneys is granted. Because plaintiff's counsel is not a party to the action, any consent deadline directed at plaintiff's counsel is inapplicable and hereby vacated. And that consent deadline is, hey, do you consent to having this case heard by a magistrate judge? And consistent with paragraph 4 of the court's scheduling order, plaintiff's proposed discovery plan controls unless otherwise ordered. And you'll notice there is no decision on the motion for sanctions. Although, like I said, I think it's going to be denied at this time based on the same discussion here. And it's dated August 8th, 2023, signed by Raymond Patrico, however it's pronounced, Chief U.S. Magistrate Judge for the United States Courts District of Idaho. So that's terrific news. I mean, it cuts the content in half from this case, but it also cuts the litigation in half. It's great news for Professor Scofield. But as promised, we have the motion to quash or modify the subpoena to Meta platforms, Meta being the dumb corporate name for Facebook. Pursuant to Federal Rule of Civil Procedure 45, this court's scheduling order, plaintiff Rebecca Scofield moves the court to quash or modify the subpoena to Meta Platforms, Inc. And I hate the separation of motions from the memorandum for the motions, but here's the memorandum in support. Introduction. On July 13th, 2023, defendant Ashley Guillard served a notice of intent to serve a subpoena on Meta Platforms, Inc. Declaration, and we have declaration of Wendy J. Olson in support of motion to quash as Exhibit A. Guillard's requests are not limited to the defenses to claims filed against her. She instead broadly requests all messages on Professor Scofield's social media accounts, all of Professor Scofield's social media connections, and all connections between Rebecca Scofield and any University of Idaho students. Those untailored requests are irrelevant and would unnecessarily invade Professor Scofield's privacy by revealing personal information such as pictures of her children and private communications with friends unrelated to this litigation. Professor Scofield thus asks the court to quash the subpoena pursuant to scheduling order as it refers to Professor Scofield as counter-defendant. And this was made before the order, but it's going to be granted because of the order. And because it's abusive even without the order, even if the counterclaims weren't dismissed. This is so overly broad and abusive that it can't be allowed. The court, in its scheduling order, specifically limited discovery to plaintiff Scofield's underlying claims and defendant's defenses relating thereto, pending the court's ruling on plaintiff's motion to dismiss. In the alternative, and pursuant to Federal Rule of Civil Procedure 45C, plaintiff seeks a modification of the subpoena to limit the requests to only information related to the truth that Professor Scofield did not have an affair with Kaylee Gonsalves or participate in the murders at the University of Idaho. And that'll be really easy to comply with, because if she doesn't have any messages with Kaylee Gonsalves or about Kaylee Gonsalves, it won't be any information. I mean, there might be messages after the fact, after Guillard started defaming Professor Scofield, but those would just, even if she provides those in discovery, it's what's it going to say? It's going to be a message to her college best friend saying, "This psycho is defaming me, saying I murdered someone I never met because I was in a relationship with her, even though I have no idea who she is other than from the media coverage. How am I in this? How is this my life?" So that would be discoverable, but that backs up Professor Scofield. That those are favorable communications for her. Background. In November 2022, 4 students at the University of Idaho were murdered at a home near the campus. As she has done since 2021 with other crimes about which there has been much publicity, Guillard devised a scheme to leverage the tragedy in Moscow for her personal gain, use her spiritual acuity to post sensationalist content online to attract clicks and make money. The false story that Guillard posted repeatedly has been described in detail in Professor Scofield's complaint. Guillard herself admits to posting over 100 TikTok videos related to her findings about Professor Scofield. But Guillard offers not even allegations of real evidence in support of her story. Guillard says her spiritual research intuitively led to the University of Idaho History Department. She then spiritually inquired into each person listed on the History Department's webpage, and her insight for Rebecca Scofield provided the basis for Guillard's false claims. Guillard now seeks to use the overbroad subpoena to discover the facts she does not have and will not find. But in the process, she seeks to further invade Professor Scofield's privacy by requesting personal information on social media that has nothing to do with the falsity of Guillard's statements. Legal standard. Pursuant to Federal Rule of Civil Procedure 45D, a court may quash or modify a subpoena if it is unreasonable, oppressive, fails to allow time for compliance, requires disclosure of privileged or other protected matter, or subjects the person to undue burden. When a subpoena to a third party impacts the interests of a party to the dispute, the party may properly seek to have the subpoena modified. That's Adams versus United States, District of Idaho, 2010. The scope of discovery under a Rule 45 subpoena is the same as a scope of discovery under Rule 26, Spencer versus Greenwald, District of Idaho, 2022. As such, the scope of a subpoena is limited to discovery which is relevant to the party's claims or defenses or appears reasonably calculated to lead to the discovery of admissible evidence. Argument. Social media accounts may be a source of relevant information that is discoverable. However, this discoverability does not grant parties a generalized right to rummage at will through information that an opposing party has limited from public view. And the party seeking private social media information must still establish under Rule 26 that the requested discovery is relevant and proportional to the needs of the case. That's citing Hidalgo Lopez versus Core Civic from the District of Arizona, 2021. Consequently, courts have denied blanket requests for the contents of social media accounts and instead required that parties bring narrowed requests for information related to the issues in the case. And that's also from Hidalgo. And see also McElprang versus Fidelity National Title Agency of Nevada from the District of Nevada, 2007, which orders the release of all the private mail messages on plaintiff's MySpace. Whoa. internet account would allow defendants to cast too wide a net for any information that might be relevant and discoverable. So basically, you can't go on a fishing expedition. You've got to use, this is spear fishing, not using a net behind a trawler to catch anything and everything. You've got to narrowly tailor it to what could actually provide discoverable information. So the subpoena violates those limits. For example, the first request seeks all messages from the past 2 years on Professor Scofield's social media accounts. The second request seeks all of Professor Scofield's friends or connections on social media from the last 2 years. The third request seeks all communications from the past 2 years between Rebecca Scofield and any University of Idaho students. The fourth and fifth requests seeks information about all content Professor Scofield has hidden from her social media accounts in the last 2 years. The seventh request seeks information for an unlimited amount of time about Professor Scofield's contact information, contact address, and location. In other words, Guillard seeks just about everything Professor Scofield has on her social media accounts, even if they have no relation to Guillard's false statements. Guillard's relentless posting of TikTok videos about Professor Scofield and the social media circus they created have violated Professor Scofield's privacy enough. Guillard should not be allowed to further invade Professor Scofield's privacy by obtaining pictures of her kids, her private messages with friends unrelated to this case, or all contact information and locations captured on her social media accounts. There is no proper use for that information as it relates to Guillard's defenses. Conclusion. Professor Scofield respectfully requests the court either quash the subpoena entirely, or modify it so that Guillard can seek only information relevant to her defenses. Dated July 27th, 2023, signed Wendy Olson. And we have declaration of Wendy Olson. She's the attorney. She has facts. She's attached Exhibit A to the declaration, and it's a true and correct copy of the notice of intent to serve a subpoena on Meta. And she swears it's true and correct. So basically, she's authenticating Exhibit A as true. And basically, that this is notice of intent to serve subpoena on Facebook Meta platforms by Ashley Guillard. And it says, to plaintiff and counter-defendant Rebecca Scofield, please take notice that defendant and counterclaimant Ashley Guillard intends to serve subpoena on Meta platforms operating as Facebook, Instagram, and WhatsApp, among other products and services, pursuant to Rule 45 of the Rules of Civil Procedure. The subpoena compels the production of documents on July 31st, 2023, or sooner, as practical, at Registered Agent Corporation Services Company. Basically, that's a server, process server, because I'm guessing Facebook, even though it's headquartered in California, it's probably a Delaware corporation. So a process server in Wilmington or Newcastle, Delaware. Pick one. Those are two different cities. And then certificate of service. So this is the subpoena to Meta platforms. You are commanded to produce at the time, date, and place set forth below the following documents: electronically stored information or objects, and to permit inspection, copying, testing, or sampling of the materials. See Exhibit A attached. And it's by Ashley Guillard. Proof of service. An explanation of Rule 45. In Exhibit A, the following terms shall have the meanings set below. So definitions of documents to be produced. What meta means, so that includes Facebook, Meta, WhatsApp, Instagram. Who Guillard is, who Professor Scofield is, what accounts of hers you want, who Kaylee Gonsalves is, the Alpha Phi sorority, the murders means the University of Idaho murders, litigation means this case, what person means communications. So yeah, who cares about the definitions? Instructions. All requests seek information from June 1st, 2021 to present. Please produce all documents, data, blah, blah, blah. So then she shows the complaint. So yeah, basically that's the subpoena. It's going to be at the very least partially quashed. It's going to be limited because it's way overbroad, and we'll see just how the court might just deny it and say try again. Because if it limits it, well, then it's kind of helping her by saying this is exactly what I will allow. Whereas if it just says denied, try again, she gets to figure it out. That's probably what I'd do at this point, but that just wastes even more time. So maybe tailoring it for her would be a good idea. But either way, I think that's a good place to end it because that's all I had planned for today. So third reminder for this video, Professor Scofield's GoFundMe linked below. Please like, share, subscribe, do all the fun YouTube-y thingies. I will see you very soon to discuss one of the Las Vegas cases, either Floyd or the late Laws. But I'll get to that next week. And thank you for joining me. I will see you soon. Bye-bye.